So before starting with the session, I would like to tell a couple of instructions to our participants. Kindly put yourself on mute for the entire session. In case if you have any questions, kindly write those questions in the chat box and I shall be forwarding it to our speakers and they will be answering accordingly. Kindly keep your cameras on for the entire lecture. So with the permission of Director Ma'am, good evening to one and all and welcome to the third day of the Luminous International Teaching Month hosted by Institute of Law, Nirma University. I will now invite Professor Dr. Purvi Pokhariyal, Director and Dean, Institute of Law, Nirma University, to officially welcome our guests.
So thank you, Neha. It's a great honor to host Mr. Thomas Valenti and Professor Surya Prakash. Both are the legend when it comes to the ADR in India and abroad. We, as an institution, we have always been, discussing about the alternative tactics, which will really help us to realize the goals of access to justice, and especially in the times of pandemic, wherein the access to justice for the billions of people has been a real difficult task. At that point in time, how do we resort to the alternative dispute resolution techniques much more, in a constructive way, so that, probably access to justice, which is a constitutional goal also, which we can realize. We are honored to have with us Professor S. Surya Prakash, Vice Chancellor of Damodar Sanjeevaya National Law University, Vishkhapatnam. Professor Surya Prakash was earlier with Maharashtra National Law School, Aurangabad, and before that, Professor Surya Prakash was with National Law Institute, University, Bhopal. And Professor Surya Prakash has led the whole ADR movement amongst the Indian legal academia. When it comes to Mr. Thomas Valenti, he is a very well-known figure amongst the Indian students. He's one of the most favorite, speakers and trainers, and I have seen at various occasions, students love him so abundantly. In any sessions, students generally do not leave him. There's so many questions and so much of interactions with him. So we are truly honored to have two distinguished speakers with us, and on behalf of Nirma University and the entire students and faculty team, I wholeheartedly welcome both the speakers. Thank you.
Thank you, ma'am. Keeping with the theme of this year's International Teaching Month, which reiterates that noble thoughts come to us from all directions, I would like to introduce all of you to our eminent speakers for today's session of ADR in current times. We have with us Mr. Thomas P. Valenti. He is a Chicago-based conflict resolution specialist offering mediation, arbitration, and facilitation services and training globally. A certified mediator, Sir has conducted numerous mediation involving civil, commercial, interpersonal, and workplace matters. We also have with us Professor Dr. S. Surya Prakash, Professor of Law for Dispute Settlement Process. He is currently serving as Vice Chancellor of Damodar Sanjeevaya National Law University, Vishkhapatnam since December 2008. Prior to this, he served as Vice Chancellor of Maharashtra National Law University, Aurangabad. He has more than 25 years of experience in academics and research, and he is also a very prolific writer and has wrote a lot of contemporary issues, specifically on commercial arbitration and perspectives of mediation. Institute of Law welcomes both of you, sir. Talking about today's topic of this lecture, it's been quite a year where the entire world has come to a standstill, even the courts and our justice system as well. And at this time of the pandemic, it has been reassuring to know how the alternate dispute resolution have come down as a ray of hope for speedy disposal of cases. Uses of ADR in such circumstances have increased the popularity and understanding of ADR tenfold than it was before. Keeping this in mind and the different reasons why ADR has been getting so popular nowadays, I will now like to invite Mr. Thomas Valenti on the online dais to initiate the lecture for today. Please, sir.
Thank you. It's nice. I was at Nirma, I think it was almost 2 years ago. So it's nice to be back on campus, even though it's virtually now. And a special pleasure to be with Dr. Prakash. My first time in India was in 2009. And I met Dr. Prakash then, and we knew then that he was really the dean of ADR in India, and had a very nice working relationship with him over the years. And it's really a pleasure to be back with the academic who really is credited with making ADR prominent amongst the schools across the whole country. And so we've been asked to talk to you about ADR, alternative dispute resolution in current times. And we're going to try to, as Purvi ma'am said, we like to have some interaction. And so we're going to try to make this a way that we are able to address the topics that you're interested in as well. But the way I thought through this is, many of you have some idea what ADR is. I have a lot of slides, and I'm not going to use them all, but I have a lot because I'm going to send them and let Nirma distribute them to everybody who they want to. So I'll put this in a format. So don't worry about the slides. The content is there for you to use in your spare time, if students and faculty have any spare time. But it'll let you know what we're going to talk about. So when we think about today, let's think about just some brief introduction to ADR. What are the current times? What does that really mean? And what's the impact of COVID on it? And then we have something that's quite current called the Singapore Convention. Let me begin by thinking a bit about what really is the current time. If we were talking last year at this time, we would have a lot of uncertainty about what life was going to be like in the field of ADR. And because the pandemic was just beginning, we weren't certain about travel, about lockdowns, about access to justice through the court system or through mediation or even through arbitration. So now we have almost 1 year of experience. And so our current time today doesn't have the fear in it or the uncertainty that we had before. There's still some elements in it. But over the past year, those of us who practice in ADR have made some pretty swift adaptation to the times and created some ways for us to deliver our version of justice to disputants who need that. So we'll talk about how we're doing that now. And then for those of you who are really interested in the legal scholarship, we have a UN treaty called the Singapore Convention on International Settlement Agreements Resulting from Mediation. That's a current time issue as well. And so that's how I'd like to approach this. Dr. Prakash, you want to say anything at the moment, or I can continue, or any thoughts on how you're going to include in your part of our discussion today?
Yeah, just you continue, I will chip in.
Okay.
After some time, because you have been going great. So these are the common forms. I will start with why I have chosen these family disputes. Because India is a country, because we know that today ADR is so popular, and particularly during this pandemic period, you have rightly said, pandemic has changed our lives. Particularly in India, it has imposed a little bit discipline regarding hygiene and other things. And because most of the times, due to lockdown, you know that in India, there was a very early lockdown. And this lockdown continued for from April, May, June, almost 3 months. And 2 months, it was so strict. And no one is allowed to leave the homes. So the husbands and wives, they were under one roof, compulsorily round the clock. It's not only for 1 day or 2 days. And there were instances, not only in India, I read the reports that throughout the world, there are cases of domestic violence and other things. And coming back to my topic, today, undoubtedly, ADR is popular. And, you know, there is a difference between East and West. Particularly in India, we have India is having a great civilization. And the civilization with the roots of more than 5,000 years old. That is, people may say that the civilization started with Indus Valley civilization, but Indus Valley civilization, it's nearly 5,000 years ago. And even before that, so when this Mohenjo-daro and Harappa fully blown cities, blossomed cities, it took another 2,000 years. And along with that, the one thing that governed the lives of Indians, that is Dharma. Dharma, it is righteousness. There is no equivalent word to Dharma in English literature. Dharma means it is right, it is a duty, it is justice, and it's culmination of all righteousness, rationality. What not everything is included in Dharma. So Dharma is the doctrine which governed the lives of Indians. So since independence, so earlier, in spite of so many foreign invasions and cross-culture fusions, but still the Indian culture as such, even though people might have changed their faith, that is practice of approaching the God in different names, but the culture remained intact. And the most crucial component for culture, which is governed by Dharma, this culture today, there are some cleavages. And the most important component for culture is the family. Society itself is different families. It may be 100 families, 1,000 families in a city, it may be some million families. But all these families, they constitute society. And because of this new tendencies, earlier in good olden days, in India, we do not know divorce, domestic violence, and so many things they have come up in after independence. And nowadays, because of the advancement of science and technology, I'm not blaming as such science and technology, but the lifestyle has changed. Suppose women folk are also coming to work, and sometimes husbands in the day schedule, women in the night schedule, hardly there could be some any interaction or a time for family life. And things are changing. And in the change of things, now there is mostly, if not all, the more and more cases are coming. The family system is breaking up. Earlier, we have this giant family system. The grandparents, great grandparents, parents, that means minimum 2-3 generations, they used to live under one roof. But because of this nucleus families, because of education led to migration. And nucleus families, wife and husband, children, so that is their world within the four walls, within the small home. And when these people are sometimes living together happily, and sometimes there are differences, and the differences, they are becoming disputes, and disputes leading to violence, domestic violence, and so many things. That's the reason why, because whatever the culture, great culture that we inherited from our great grandfathers from generations, I thought that this is the duty of the present generation. The present generation, including those who are old, those who are in the middle age, and the youngsters, and particularly the students who are the hope of this nation. This is the generation, the young generation is the hope of the nation. So when modernity is welcome, we should follow, we should take advantage of science and technology. Simultaneously, we have to maintain, keep up our family values. So when once the race that ignores its culture, its future will be bleak. and more problems, new problems will come up. So that's the reason why I considered that ADR, particularly the mediation, the conciliation, these are the methods, the best methods. Even this Law Commission report 222, and also in the Afghan's case, Justice Ravindran, they have pointed out that for family disputes, the best way of resolving the family differences is through mediation. And that's the reason why this is the background why I have chosen this topic, ADR in family disputes. So today, if we want to protect the family, if the family is break up, and then it will have disastrous consequences, particularly the parents who have children. Seeing now this has become a norm even in India, single parent child. My child, I'm single parent. So if he has mother, he will be missing the father. If he has father, he will be missing the mother. But a child has a right. Even that's Convention on the Rights of the Child, and UNO has to recognize a child has the right till a particular age. As long as he is child, he should have the protection, care, love, and affection of both the parents. And parents, they have no right to deny their child the protection, the guidance, the care, the love and affection. A child is the product of both man and woman, both mother and father. So this is my submission. So keeping in view all these things, I thought that I should share my thoughts, my opinion for restoration of family for the child. So for the best, if at all there are any differences, most of the families, there are no differences, they are living happily. But wherever there are differences in the families between wife and husband, the best way is mediation. Because tomorrow, because of this nucleus families, we are missing the guidance of grandmother and grandfather. So with this in view, I thought that in ADR, no doubt arbitration is good for commercial disputes, international commercial arbitration. They are good at their own place. But for family disputes, I thought that mediation, negotiation, and conciliation. This is the background of my topic, in which I would like to discuss more. Thank you. Thomas?
Great. Thank you, Dr. Prakash. So that's a really good example of how mediation can serve the needs of people. And that's really what we as professionals try to do, is identify needs and determine what is the best mechanism for people in conflict to get their issue resolved. Doctor was talking about family issues. And in these times, we use platforms like this to do that. And so just yesterday, I had a conversation with a colleague in Greece who is mediating a family matter involving a client who's Egyptian. The dad's in Egypt, the mom is in Greece, and they're going to use a platform much like this to resolve. And there's children involved, Doctor. So it involves a lot of issues, but in the pre-COVID era, people weren't as comfortable using technology to resolve disputes. And now it's quite important because that we learn how to use these mechanisms, because that's how we can deliver justice in a more efficient way. So let's just go through a couple things. In the field of ADR, we talk about these different kinds of mechanisms: negotiation, facilitation, conciliation, mediation, arbitration, and then there's some community dispute issues as well. These are all alternatives to litigation. And so when the term ADR was created, it was always looked at as an alternative method to a court case. And so nowadays, many of the big firms have a big category of staff that's called the dispute resolution department. And within that is litigation and all these other services. And so negotiation is probably the most simple one. It's you and me trying to resolve a dispute with ourselves, between ourselves. A facilitation is very informal, and we may be having discussion amongst many different stakeholders or interests. It's often done with regard to political issues, or for example, in my neighborhood, they wanted to install a new art exhibit near a train station. And so we had a facilitated conversation about whether the design of this particular project was suitable for our neighborhood. And that would be a facilitated conversation. Mediation, Doctor talked about, it's two people hiring a third person, a neutral third person, to help them negotiate their dispute. Don't pay so much attention to these words because we'd rather have you listen to us, and then I'll give you all these slides when we're done. What you can do is ask questions while we're speaking. And so we have Neha's going to help us manage the questions if there are any. So this would be great if you want to participate. It's easier for us if we are talking about the things that are important to you. So at any point in time, I think in the chat, Neha, you can post a question in the chat, and Doctor and I will try to address those as best we can. So we talked a little bit about mediation already. You all know what that is. Conciliation is a uniquely defined in India under the 1996 Act. Here in the States, we don't use conciliation the way you do it. More often in the States, conciliation is a tool designed when there's a public interest at stake. What do I mean by that? For example, if the railroad workers are going to go on strike because they don't have enough pay, if they went on strike, the whole country would shut down because the train service would be ended. We have a federal conciliation service that acts kind of as mediators when there's a national or multi-state dispute that can affect a large population. In your role is different. This you can pick up later. Arbitration, you probably study this. Some people call this private, rent a judge or private justice. And so those of us who sit as arbitrators, it's a bit like litigation, but it was designed to be more efficient, more cost efficient, more time efficient. If you have a dispute with somebody and you have a contract that requires it to be resolved by arbitration, that means that somebody like myself or Doctor or anybody on the call who's trained as an arbitrator will sit and make a decision for you. We get compensated through whatever mechanisms are existing in the scheme that you're under, but you get a final decision called an arbitration award. And we take testimony, both written and oral, and we have a solution given that we decide. In mediation, the parties decide it. In arbitration, the arbitrator or arbitration tribunal decides it. And that is usually determined to be a final award. There's very few mechanisms that can be used to appeal that. In India, I can let Doctor talk more about that, but there's some new laws that have come in recently about the sanctity of the award and what mechanisms are available to appeal that. And I think in 2016, or was it 19, Doctor, there were some changes in the Arbitration Act that allow, that restrict the ability to challenge an arbitration award. Am I right, Doctor?
Yeah. So, Mr. Valenti, may I add?
Yes, please.
Yeah. So the basic ADR methods Professor Valenti has explained. And in the Indian context, I would like to add one more, that is judicial settlement. So in India, we have this Civil Procedure Code, Section 89. It provides different kinds of ADR systems. It starts with arbitration, conciliation, mediation, judicial settlement. So when and also legal services under the Legal Services Authorities Act, we have local adalats. So in US, what I observed, what you have stated, the methods, and also there are some hybrid methods, that is starting with mediation and then ending with arbitration. And whereas in India, we have the statutory backing under Section 89, arbitration and conciliation, they are governed by what is said Arbitration and Conciliation Act 1996. And we have this local adalats. That is, the judge will act like a mediator come say, conciliator, and thereby actually the contestants before him, he will try to settle the dispute through Lok Adalat. The same judge, he will decide the matters, he will adjudicate the matters, and if he finds that yes, there are some elements for the settlement of this dispute, he may refer the matter to the Lok Adalat. And the beauty here is the same trial judge, he will sit there as in the Lok Adalat as the judge, the presiding officer. So he knows the whole facts and the arguments of the matter, the opinion of the parties and their counsels. And when the matter is referred to the Lok Adalat, there as a presiding officer, he will try to bring a settlement between the parties. It is totally voluntary. It is totally voluntary. That is, court itself will settle the dispute in Lok Adalat. And similarly, there is also another component like judicial settlement. So without any trial, without any formal litigation, the court will, so best and worst example of judicial settlement in India, it was a Bhopal gas tragedy case.
Yeah.
So where the court, the judiciary has brokered the deal between UCC and the Union of India. It was, the case was not decided on merits, but it was a judicial settlement. And then we have this mediation. For mediation, there is no law. For all other things, there are all other methods of ADR, they are backed by the law. There are certain legal provisions. But another component is this mediation. For mediation, there is no backup by any legislation. And negotiation is not in the list in India. Under Section 89, negotiation is not there. Why? Because negotiation is basically between the parties. They directly approach the other and they will discuss and decide and settle the matters. Probably that might be the reason why they didn't include. Otherwise, we have this legal backup for arbitration, conciliation, Lok Adalats, and judicial settlement, except mediation. Mediation is a freelance. It is like freelance journalism. So anybody can do anything. The provided, ultimately, it is reduced into a settlement on paper. So just because the Constitution of India guarantees justice to all, and both through courts and outside the courts. And here I would like to, for the benefit of the students, I would like to add one more thing. The basic difference between litigation and ADR. In the case of litigation, parties always litigate for protection of their rights. The litigation is rights-based. The parties, they take up the stands. They will take their positions and they will fight for their rights, for the enforcement of the rights, for the recognition of their rights. But whereas the ADR methods are concerned, except this arbitration, these are interest-based approaches. So in ADR, the mediator, conciliators, and ultimately the parties also will realize where my interest lies. It is not the question of rights. It is a basic, I want that my interest should be protected. Even in commerce also, if X, he has given a loan of 1 lakh rupees to Y, why he didn't pay for a long time. And ultimately, the mediation and conciliation, okay, you need not pay the interest. Just you pay the principal amount. That is, in one way, it would be no loss, no gain. Because why he was suffering losses in his business? He will be readily willing to pay the principal amount. So there was a waiver for the interest. And similarly, even particularly in the case of family disputes. Family disputes, they are more interest-oriented. The mediator or the conciliator has to look into the interests here it is not only the interest of wife and husband, they also have to look into the interest of their children. So no parent has the right to disturb the childhood and future of their children. So this is what I'm trying to evolve in this settlement of dispute, family disputes. So thank you, Valenti.
Sirs, I would like to interrupt just. There's one question from one of our senior faculty here at ILNU. This is a question from Dr. Anand Kumar Shinde. He's asking, what is your opinion on making pre-litigation mediation mandatory in commercial disputes? Sirs, your opinion on that?
That's for me, right? Or Dr. Prakash?
It's to both of you, sir, actually, this question.
Okay, I'll go first. It's a good question, and many countries are struggling with this now, is mandatory mediation before you go to court. And so if I can take a moment first to describe what mediation is, it's basically a voluntary process where two people decide to use a third party to assist them in reaching a settlement. And so those of us who practice mediation put great value in the concept of it being voluntary. So we struggle with this idea that it's going to be mandatory, because for us it takes away the notion that those who come to me for mediation are there because they want to settle it. If some judge says you must go, we struggle with the idea that people who are forced to be there, and their interest in resolving it may not be the same as those who aren't. And so that's the background on it for me. What I think mandatory pre-litigation mediation does is it creates awareness of the process, awareness of mediation as a dispute mechanism, dispute resolution mechanism. One of the first countries to do it was Italy. The initial law there was declared unconstitutional because it made it mandatory. And now they have a different scheme in place. Greece just started a new scheme where they don't require you to mediate pre-litigation, but they require you to visit with a mediator to learn about mediation, and the lawyers and the parties must be there. So they developed a scheme that didn't require you to mediate, but they required you to learn about it. And it's still in its infancy, so we're not, and COVID shut a lot of things down, and so we don't have a lot of data yet whether mandatory pre-litigation information sessions are successful. I think they will be. But before Dr. Prakash makes his comments, I'll make one more. If I'm in a jurisdiction where it's mandatory, I think for me, it's a challenge for me to bring out my best skills as a mediator. I have somebody who's not quite voluntarily there. And so it's my job to do a good job explaining the fairness of the process, how it works, how it might serve them better, time-wise, economics, and about their decision-making power rather than the judge's decision-making power. So I think mandatory mediation in some scheme can give us the opportunity to let the parties take control of their dispute. So I'm not against it, but I think in those countries where there's not a big uptake, it's great. And I think in family cases, I'll let he might have some interesting comments about mandatory in family. So I'll turn it over to you now, Doctor.
Okay. I would like to supplement some more information. The question regarding commercial disputes. So please remember, my dear students, we have only one CPC, Civil Procedure Code, and Section 89 is applicable to all civil disputes, irrespective of the court. Of course, there are certain exceptions like the labor courts, the industrial courts under the Industrial Disputes Act, the family courts. For them, CRPC is either not applicable or limited applicability. For the general courts, CPC is applicable. And if you look into Section 89, which is much advanced in the sense, why I'm saying that this is much advanced, the trial judge he is empowered under Section 89 whenever a case is filed before him, any civil matter, whether it may be regarding the succession, whether it is a commercial dispute, or whether it is a contract or a financial matter, anything. The trial judge under Section 89, first of all, he will look into the nature of dispute, and if he satisfies that there are elements for the settlement of the dispute, if he satisfies that if there are in the given case, there are elements for the settlement, and now he can test. So for this particular dispute, which mode of ADR is more compatible or more suitable? Whether this dispute should be referred to arbitration, whether this dispute should be referred to mediation or conciliation or judicial settlement or local dalat. So a discretion is given to the trial judge. So if for a particular dispute, suppose if it is a family dispute, he may refer the matter to mediation. Or if it is a commercial dispute, he thinks that yes, this is a dispute more suitable for conciliation, or for that matter, arbitration. Of course, for arbitration, again, please mark it that it is a kind of adjudication process, and where the consent of both the parties is necessary. So that's the reason why under Section 89, the trial judge, he is empowered with different instruments. That is not only mediation. Depending upon the nature of the dispute, he may apply any method at his disposal. That is under Section 89. So for commercial disputes, or for that matter, any civil dispute, Section 89 is applicable, and trial judge, he has to test it, whether if he considers that yes, the matter could not be decided by any of these ADR methods, then he may start the regular litigation. Okay, I think that the doubt is cleared. Okay.
So let's think about this for a moment. So we have, and I'm going to relate this to the pandemic. And so if our job, if we study law, practice law, or teach law, is to deliver justice to people who have a need for justice, and something like the pandemic occurs, we're in this situation where the access to justice is unavailable to almost everybody across the world. And so we began to think about this at the beginning, is that take a simple matter, for example, of a woman owns a building and she gets rent from people, and the tenants can't pay rent because the government has closed their store. She needs the money. She can't go to court to get a remedy because the court's closed. And so you can take that example and apply it across the globe. The pandemic was really the perfect storm. It created, or in your language, the perfect monsoon. Although you like rain more than I like rain, but what happened was we had this enormous shutdown. And so when we began talking with people who were affected by it, and it was everybody, we also began to think about dispute prevention, which is why I put negotiation in as one of the things, because we were recommending people that they review their contracts, their relationships, and decide to begin a negotiation. We know that we're not going to be able to operate here. Can we amend our rent provision? Can we create a different timeline for shipping? Can we create another methodology for us to look at breach of the contract, because we're all affected by the same thing? Those people who don't have access to a court system could then decide if arbitration is the result of a contract, and the landlord and tenant have the right to go to court. They also have the right to sign a contract that says we're going to hire Purvi to arbitrate our dispute, because I can't get into the courthouse. I need a decision. And so we sign an arbitration agreement. And it says we hire Purvi, her decision stands. So we've given them access to justice by a contract. The problem is, in the old days in arbitration, I would need to be in Purvi's office. I'm the tenant, and Neha owns the building, and so we need to go there. But COVID made us learn that we need to access justice in a different way. And so we began to use online mechanisms to give people justice that way. Instead of arbitrating, we could decide to mediate that dispute as well. And we would use a platform like this to mediate. So when COVID happened, everybody was in this odd position that they had to become innovators immediately. And I'll give you a personal example. I work with one of the international organizations, and they do arbitration and mediation, and there's a lot of senior people on that. And you guys know about the digital divide. Some of us aren't so good at technology. And so there was a group of mediators who thought they were out of business because of COVID, that they were never going to be able to practice again because nobody was going to hire them to do something online. Even if they did, they didn't know how to do anything. A cute story, and I won't mention his name, but we did a week-long training in technology to get them mediators up to speed. And we're using Zoom. Now everybody knows Zoom, right? Raise your hand if you don't know Zoom, because we all learned that quite a bit. I was using Zoom about 5 years ago. We started training mediators in Zoom in cross-border disputes, because it became very efficient. If I have a client here who has a dispute with somebody in India, instead of traveling back and forth, we could do it online, and we could save time and save money for those people. So I had pretty good familiarity with it, but there were a lot of people of my generation that didn't. And so we're doing the training, and somebody, you know how you share a document on Zoom. It seems pretty easy. And the gentleman couldn't share the document. And he said, "Tom, where's my document?" And I said, "You should have it on your desktop." And he, "Where's my desktop? I can't find my desktop." So we learned that the digital divide can be pretty big if you're not using it at all. And so even normal things that you and I may know about mouse, touchpad, desktop, whatever it might be, these tools. So we began to re-educate ourselves, and senior people had to re-educate themselves too. That gentleman went on, he graduated from one of the Ivy League law schools here, and he was supposed to host their alumni meeting. And he went on to host online alumni meeting, and he created breakout rooms, what he called cocktail rooms, and he put people in rooms. So he learned. He's a smart guy if he's Ivy League, right? But we just had to get him over that digital divide. And so in terms of dispute resolution from a year ago till now, we've made great strides. And so that's why I said, let's talk about what are the current times. A year ago, we were nowhere. Nobody knew what to do, how to do it. Then we now have in Chicago, where I am, the court system using Zoom hearings as well. Nobody's in the building for the most part. The judge is at home, litigants are at home, and their lawyers are at home. And we might have a court hearing with as many people as you see on the screen here. It could be 10, 12 lawyers. And the court is doing that as well. It took them a while for them to get to that stage. Other mechanisms were put in place to ensure some kind of security. In the field of international arbitration, the use of technology was a bit more of a hurdle. We know we can use it all, but lawyers are generally suspicious people, right? I mean, we kind of were taught to do that in school. And so I've been involved in situations where if there's an expert witness talking about, let's say it's an engineer, a construction dispute, some failure, and there's a construction engineer who's testifying, the rules are generally that the person is not able to get advice from anybody else. He can't be prompted by anybody. He can't look at any documents other than the report that he prepared. And that's the way it would happen in person. And we could see that real easily, right? He's sitting at the head of a table. We're all lawyers asking him questions. We know the paper he has in front of you, and we know that nobody's whispering in his ear or holding up the answer above the screen, right? So lawyers being naturally suspicious now in international arbitration, we're saying the integrity of the process is compromised. Why? Because he can cheat. And so now they have the system with multiple cameras. Turn off your cell phone. They ask you to take your camera and scan your desk beforehand, scan the whole room to make sure nobody is there. But it works. Do you know somebody's not giving me the answers on my phone while I'm talking to you? So they have developed systems where if you look away too long, or if you're looking down, somebody's going to ask you, well, go scan what you just looked at, right? Well, what were you looking at off screen? And so gradually people started to use, in the past year, this technology or others with international arbitration matters as well, and created some mechanisms for the parties and the lawyers to believe that the process was fair. And it takes us a little bit of time to decide what's fair, and a little bit of experience in the process. So as the year progressed, more and more people are comfortable using technology for international arbitrations as well. And so, and maybe you can weigh in on this, everybody on the call, the question really becomes, in current times, well, let me talk about mediation first. So mediation online is quite easy, right? Because we don't have, it's not evidence, right? It's just conversation. So we do the same thing for online mediations. Some people worry that somebody else is in the room. We ask people, because it's voluntary, to say, I'm here alone. But in mediation, because it is so relaxed and so informal, we don't have this questioning the integrity of the process. So we all shifted quite easily to mediation online. We gradually shifted to arbitration online. And here we are, basically a year after the pandemic, and everybody is doing this every day. I did an arbitration Monday afternoon. It was a short case online. People are doing them all the time. The tribunals have created digital information systems that allow me to access via a portal the documents. So I can be any place, not my office. I'm calling you today from my home, but I can be at home and do this. We have a way to exchange documents and protect the security of it. The security issue, and then I'll stop and Doctor can weigh in on this, but I want to talk about one more thing that's crucial with regard to international arbitration. And those are the cybersecurity issues. When I first started doing this, do you guys all remember when Zoom was banned in India?
Yes.
Because of the Zoom bombing? Yeah.
Zoom was banned.
Yeah, you students caused the problem because you were putting stupid pictures up during class, and so they banned it. But the real issue, it was good that you did it because it made the platform developers create more security measures. And so you tested the authenticity of it or the reliability of it and awakened a lot of people to extra security measures that were put in. I started using Zoom before there were breakout rooms. And so I'm back on Zoom, 1.0, which is decades ago, not decades ago, but versions ago. And in those days, you guys know what a breakout room is? There was no such thing. You just put somebody on hold. So you would look at a screen that said you are on hold, and you couldn't hear me in the other room. But the cybersecurity issues that caused the banning in certain jurisdictions have been, for the most part, resolved. We have passwords now and the waiting room and all these other things. So most of us feel pretty secure in the platform. The real question is the security of the documents. And so if we have a hearing, and imagine a case now involving a pharmaceutical company. And in big pharma, there's big money, and they're all publicly traded companies. And if you know that I'm an arbitrator on what we call a market changing case, in other words, the decision can cause the stock to go up or down, they may not be able to hack the ICC portal, but they may be able to hack my email and get documents from my account. And so we've spent a lot of time this year with smart young people like you trying to manage technology to make sure that we don't access our server from Starbucks or somewhere where the security protections don't exist. Recommending people maintain your own VPN, do that, travel with it, and don't access in airports coffee shops or whatever. And nothing against Gmail, but don't use Gmail for anything in a case, because there's some vulnerabilities there that we want. And so you want to protect the privacy of the disputants. And so big steps have been made as a result of COVID to make us go forward. And I think before we end, we'll talk about, do we ever go backwards, or are we in this for now? But I'll be quiet for a bit and let Doctor weigh in on this topic.
Okay. Yes. Yeah. From what Mr. Thomas has stated, in a lighter vein, we in India, we are the giants in IT. And hardly we use this online dispute settlement mechanisms. Almost we have an aversion. And the attitude of the Indians, still majority of Indians, if not, may not be all, majority of Indians, still they have a lot of faith in the traditional court system. Judgment means you should go to the court again and again for various adjournments. You should stand before the judge, and there should be cross-examination, examination chief, and all this whole process. After that, if I get the judgment, then I will be on Mount Everest. So the psychology of Indians, most of the, even if we say that, okay, you can settle your matter through mediation or arbitration, they will look at you with suspicion. Not only the advocates, even the common man, still they didn't have any faith in this ADR mechanisms. So that's one thing. That is basically the difference between the US population and the Indian population. Still, we are traditional. Still, we believe in the court system, and that is the justice should be hard earned. It should not come in 1 or 2 sittings by settlement. If a lot of adjournments and going to the advocate's home and waiting there and then going to the court, and after all this time, if I get judgment in my favor, then I am the happiest person. So this is the mindset. And in COVID times, you have well said that in the developed nations, this is the misfortune of India. That is, even though we are IT giants, we have every technology is available. We have every technology is available. And even today, the class first student or even UKG student, he is attending the online classes in his dad's mobile. But the mindset, and because I studied the US justice system, and in I think in the state of Michigan, Lansing, I went to a county dispute settlement center. It's for maybe some 20-25 miles away from Lansing, and it's a dispute settlement level, like in a village. It's a dispute settlement center. The moment I entered, the first it is Mahatma Gandhi who has invited me. There is a very big photo of Mahatma Gandhi, and don't litigate, settle the matter, with a caption. So even Mahatma Gandhi was so popular there, and in a very informal way, all the travel matters, that is barking of dogs, hens, chicks going into the other campus, or drainage water going into the neighbors. So all these kinds of disputes and shouting or resounding. So people, they need not go to the court. So voluntarily, they will go to the dispute settlement center, and their things are settled by parties sitting together and discussing in a very informal way. So that kind of easiness in India, still access to justice itself is a very big issue for Indians because of the population and because of the number of courts, because of number of judges, docket explosion in the courts, because of the pendency. And in spite of supporting this ADR's methods by the courts, by the government, and also by the law schools, but still the mindset of the people, it is not picking up. Probably it may take some more time for the transformation. See, a settlement by in mediation or in arbitration is as good as a judgment. We know that in law, an award is equivalent to a decree of a court. We know, but a common man is not aware that the settlements are as good as judgments. They are also like decrees of a court. So that's where the ADR was struck because of the mindset of the people. And because though online facilities and technology is available, but still we are striving to use those technologies for this purpose. For other purposes, we the Indians, we are the best in using the technology for movies and for many other things on the internet. But when it comes for ADR, so we are lagging behind because of the mindset. So that's where we have to conduct the awareness campaigns. And you have well said that, yes, in the pandemic, this is the best mode. This is the best way to address the disputes, or if the differences are addressed. Being human beings, because no two persons will think alike. Everyone is having their independent mind. The same thing will be looked by different people in different ways. When automatically there could be some difference of opinion. So the most civilized way is to discuss and to convince the other. Otherwise, the disputes will transform, the difference will be transformed into disputes. Then all these things do necessary. Yes? Yeah.
Excuse me, sir. So pertaining to COVID-19 situation, we have another question from one of our faculty colleagues, Dr. Bishwa K. Das. In view of event cancellations, implication of force majeure, impossibility, impracticability, and frustration of employment in sporting arena posed by COVID-19 has brought opportunities in terms of area for some and challenges for the adjudicatory organizations at large. In line of COVID-19 situation, though the Court of Arbitration for Sports have come up with e-filing and stopped in-person hearings, but finding attorneys and knowing the procedures has always been witnessed as a problem. Do you think the ease of process while contingent factors of ADR is going to help the sports litigant at large?
Yeah, this is a good question, because the Court of Arbitration for Sport, there's not a lot of people who practice there. And now bringing it online, you have more access to attorneys, because if and I don't practice there, but if I did, it may take me some time to schedule to get to Stockholm, for example, if that's where we're sitting. And now I can do that tomorrow morning. The time differences are important, but we've enabled people to participate in adjudicatory processes, whether that's court or arbitration, with less costs and less time commitment. And so I think that's where we are today, is that COVID took away a lot from us. You know, I mean, this is miserable, right? But everything that happens to us, we can look at as an improvement as well. So I can look at the dispute mechanisms that are around and find that, in fact, we improved some of them. We made justice more accessible. We created technologies that are more servable. And so I think with regard to the arbitration issue, sport arbitration, we're going to see perhaps not maybe less practitioners there, but accessibility to the seasoned practitioners who practice in that jurisdiction, because they can handle them more easily remotely than they can by flying to that destination, as is true for the athletes themselves or their counsel. If we look at the year, and this is going to apply to arbitration now as well. So why did we move to an online mechanism? So we wanted to save money, keep the costs down. We wanted it to be more flexible, right? And the flexibility comes through the process itself. We wanted it to be fast, and we wanted to cross borders. We wanted to be able to access justice for people in different geographical locations. And we also sometimes have people who are reluctant to do it or who are angry, and the online mechanisms let them participate in a way that's more comfortable for them. And if we have particularly aggravated people, we can do that. And so what we saw over the past year in moving from face-to-face to online, we saw some skepticism at the beginning. You know, there was a lot of pushback. There was a lot of resistance. There were people who didn't have the digital skills yet. And now I think it's been embraced by most places. And the real question now is, this is a reaction for some people who might have difficulty adjusting to it. But right now, we think that it's opened up lots of possibilities for people. And that's the modern world of dispute resolution. And the courts themselves are seeing this. The problem I see going forward, and it'd be nice to have a conversation with people on the call about this, is, are we going to go backwards? Are we going to ever go back to full no mask, no lockdown at all, and the whole world is vaccinated? Maybe, but I'm not so sure when. And the question we have is, at what point can you force a party to appear in person if they're anti-vaccine or whatever their situation is? And we found that justice can be delivered without in-person exposure. We study this as arbitrators. Do I, as an arbitrator, have the authority to say, this is going to be online? There are parties who use this as a delay tactic, that say, we want to be in person, so we're not going to agree till then. What authority do I, as an arbitrator, or I, as a judge, have to order people to appear in person or order people to appear online? That's a conversation that differs from country to country. And if there's open questions now, it's that. What's the next phase? And I don't have an answer to that, but it would be interesting to hear people's thoughts about that. Is, where do we go from here? You know, we're kind of comfortable working from home, doing this, doing that. Some people are affected more by it than others, but is this the new reality? Or is it something different than the old reality? Do we have to invent something that accommodates the interest of everybody affected by a pandemic, or perhaps the next pandemic? Any thoughts on that? Or other questions?
So we have another question from one of the students, Aryan Garg. Sir, how can we introduce mediation in criminal matters? How can it be effective in speedy trials right now, looking at the situation?
That's probably for Dr. Prakash, yeah.
Yeah. See, if you look into CRPC, there are offenses. That is compoundable and non-compoundable offenses. So if you mark the difference, there are certain offenses. Compoundable means which can be compromised. So if both the parties, they agree. As such, there is no ADR. Please remember, as such, there is no ADR for criminal matters as a matter of right. But for CRPC, in certain offenses, I think less than 3 years or something, I'm not quite sure. For certain offenses are brought under the category of compoundable offenses. And for such offenses, if both the parties, they agree, then the court may make some settlement or compromise. And basically, crime is an offense against the society against the state. Crime is an offense against the general public. So the prosecution is the duty of the state. On behalf of the society, it is the state which will prosecute the accused, the offender. And as such, the courts, there is no total what you call exception from criminal liability if once the offense is committed. Okay. So as such, first principle is as such, there is no ADR mechanism applicable to criminal matters except for those offenses which are brought under the category of compoundable offenses. And number two, a few years back, the CRPC was amended and the concept of plea bargaining was introduced. The concept of plea bargaining was introduced. As far as this plea bargain is concerned, it is initially originated and developed in United States. If I remember correctly, even the assassin of John F. Kennedy and in many cases, the accused, they pleaded for this plea bargaining. So in plea bargaining, the theory is that the accused, he will confess. The accused, he will confess his guilt or the crime. And now what is bargain? The bargaining is for sentence. It is not for total acquittal, but instead of maximum punishment, because he has already confessed and thereby he is saving the time of the court and the resources of the state, etc. And in a way he may express for his reformation. So then he will bargain for, suppose if the section 309 attempt to murder 307, the maximum punishment is 7 years or 10 years. So if he confesses, the judge, he may bargain with 7 instead of 7 years, he may reduce the sentence to 4 years or 3 years, something like that. The bargain is only regarding the quantum of sentence, but not total exemption from sentence. So these are the only two things available in criminal law. One is compoundable offenses. The second one is the concept of plea bargaining, which was introduced some 10 years back. And even this plea bargaining is also not much successful. Initially, because I am the trial judge, and the accused, he has to confess. And instead of 10 years, the accused, he may expect that the judge will give him only 2 years or 3 years. And the accused expectation is 2 years for 10 years punishment. And the judge, he wants to give a concession of 2 years. He wants to give him a sentence of 8 years. So there is the bargain is not successful. So if the bargain is not successful, what will happen? The trial process will continue. So the trial process will continue. And being a judge, being a trial judge, I know that he has already committed the offense. So there could be bias. And of course, this was the initial position, but later on the provisions were amended. Then the matter will go to another judge. Even for another judge also, it is recorded that the plea bargaining was attempted and failed. That means even if it goes to the next judge, when plea bargaining failed means it is natural that this fellow has confessed and it is implied that he has committed the offense. So logically, there are some hiccups in enforcing this plea bargaining unless and until there are some standard guidelines. That is, if the person confesses his guilt, then he should be given 25% remission in his sentence, or maybe 50%. unless there are some guidelines. Even this plea bargaining, as of today, plea bargaining is also not much successful in India. Okay, so forget ADR in criminal matters except compoundable offenses and plea bargaining. These are there in the statute book. Okay.
I just weigh in one thought on this. I gave a talk on this actually in Pune about 4 years ago, and we do something in some jurisdictions called victim offender mediation. And I believe that it's within the umbrella of what we call restorative justice. Quite interesting to a lot of people. Actually, there's an organization in Delhi called Council to Secure Justice, who I've done some work with them. They do this with juvenile offenders. And so this notion is particularly applicable to first offenders and young people. And how does it work? I think the statute actually at some point, I'm not remembering it precisely, but says with input or consideration of the impact on the victim. And so I argued in Pune that your criminal code allows for this process. And the process is in minor cases, not non-violent, so no rapes, no murders, no physical assault cases, usually selected by the prosecution, first offenders or juveniles. We have a mediation, and we hear from the person who did the crime. The prosecutor is there and the victim is there as well. And the end result might be that there's a solution that is not that ends up approved by the court, but doesn't end up in incarceration. And so we know from our work in the US that the best place to learn to be a better criminal is a jail or a prison, right? And so if you take a first offender and put him in the school to become bad, he's going to come out with a PhD in crime. If we keep him out of that jail and maybe do community service or something like that, maybe we've saved somebody's the rest of their life. And it doesn't happen in India, but that's what we call victim offender mediation. And it's proven to be, there's great success stories. And I'm sure we don't hear about the bad stories that people go on and become a repeat offender. But I think you have the same problem that we have about our prison system, very overcrowded, all kinds of people there. And you can, in our system, you can end up in a prison because you stole candy. And you can also end up in a prison because you murdered somebody. And to mix those two people in the same institution is not good. But the idea of plea bargaining has been around for a long time. But I think if we look at justice and social justice, the idea that we can create a system to keep young people from getting that PhD in crime, we owe that to our society. And in a country as big as yours, it's hard to implement across the board, but in isolated places, there might be a chief justice or somebody who wants to implement that.
Yes. Yeah. The fundamental difference between the US system and Indian system. If you look into the Indian Penal Code, except the recent amendments for rape and some other.
He froze.
We lost his voice. Hello.
Yeah, the camera's frozen.
Ma'am, it's frozen.
Was there another question, Neha?
Yes, sir. So this is a question to you, sir. This is a question from one of our students, Tushar. How far has mediation and negotiation turned out to be a successful method of diplomatic settlement between inter-country disputes, for example, in light of recent diplomatic dialogue exchange between India and China on account of border disputes?
Yeah, well, that's really the heart of negotiation is the heart of international diplomacy. We know that it's created all kinds of treaties between countries around the world. Highly sophisticated people do it, and it takes an intense historical knowledge and lots of issues. I happened to be on a session with this organization the other day, and You may have heard of a general in the US, General James Mattis. They call him Mad Dog Mattis. It was his nickname. But he gave a talk about his work as a four-star general in Iraq and in Afghanistan, and he talked about these kinds of issues to Shara, about diplomacy. Is that many times he said, I've slept with murderers sometimes, but we shouldn't look at international disputes as always requiring a force, that perhaps the force, physical force by weapons, but perhaps economic force or other kinds of restrictions on behaviors can create peaceful solutions in certain places. We're looking at places now, North Korea, Afghanistan. You can look at all those places, the fights over the South China Sea. There's people working on the Jordan River dispute where water is taken by countries surrounding that, and they all end up as a result of negotiating with diplomats from each country. And so I think, call it a mediation, call it a negotiation, many times there's a third party who's asked to intervene and be the facilitator of those conversations. But I think that's what keeps disputes from becoming wars. And so very interesting field. And if somebody has an interest in that, I would encourage it, because we need young people to move up through the ranks and become the leaders of diplomatic corps.
Thank you, sir. So we have another question from one of the students, from Shruti Sinha. There is always an attempt to influence the decision of judicial authorities by the corporate parties, and there can be fair chances of their success in same. Against that, in times where arbitration law is still in developing state and struggling to establish its efficiency in many countries, how difficult it is to come up to a settlement for an arbitrator when the authoritative powers of the arbitrator are also very limited compared to the courtroom judges?
Well, in international or in domestic arbitration here, I sit as a judge, as an arbitrator. I decide the case, and I have most of a little bit more flexibility than a judge in terms of scheduling and all that. But our award becomes just like a judicial judgment. And so I think the problem in some countries is that they don't trust their arbitrators, and so they use judicial mechanisms to alter an award after it's entered. But in my experience, the award of a tribunal operates like a judgment, and so we have lots of authority to decide issues, decide who's going to testify, how long they're going to testify, and nowadays, whether it's online or in person. I'm not sure I answered the question, but if I didn't, come back at me again.
Okay, sir. So there are a couple of more questions. So this question is from one of our faculty colleague, Mr. Kushal. While preserving families is a concern, lawyers have also pointed out that excessive emphasis on reconciliation in family matters by mediators and judges has actually led to wives losing their lives because of forced reconciliation and telling her to go back to her husband. They have argued that mediators thus act as patriarchs rather than coming up with a just solution. How does one balance individual rights and importance of families as an institution?
Obviously, for Dr. Prakash, I'm really interested in your answer, Doctor. Good question.
Yeah. Can you hear me?
Yes, sir. Yes.
That is okay. Because I think that a video struck somewhere.
Your voice is clear.
Yeah, voice is clear.
Yeah.
Yeah. Could you repeat the question in brief?
Yes, sir. So while preserving families is a concern, lawyers have also pointed out that excessive emphasis on reconciliation in family matters by mediators and judges have actually led to wives losing their lives because of forced reconciliation. They have argued that mediators act as patriarchs rather than coming up with a just solution. How does one balance individual rights and importance of families as an institution?
That is, the mediators, they are not trained properly. The mediators, they are not trained properly. See, in India, what's happening, I am a lawyer, and later I will become a judge. And I am with a mindset of 30 years in litigation or 35 years, 40 years. And then I will jump into arbitration, and then I will do mediation. And I can do anything. I can do anything. That is a mindset of the legal professionals. But in developed nations, for example, in US, if you go to an ADR center, maybe in Texas, maybe in Washington, maybe in any other city, in the ADR center, you'll find mediation means you will find a room, and mediators will do mediation only. Arbitrators, they will do arbitration only. And negotiation means it's a total. So mediation is totally a different ballgame. And the moment an untrained graduate or legal professional, he enters for me in the mediation room, he thinks that he is the sovereign. Instead of facilitating openly for discussion, and what he will do is, and the first trait of a mediator is he should not be judgmental. He should not be judgmental. And he should be a first silent listener. And after listening silently, and he should get the facts, and he should know what are the interests, and he can only suggest the ways and means for a settlement. But the moment he starts adjudicating, or he feels that he is more superior than the parties, and parties are his subordinates, the results, the outcome will be what you are saying. So there, it is not the problem with the mediation, but it is a problem with the mediator. So if anybody wants, you have very best guidance. So the communication, what the mediator has to, you should be very careful with his communication. You should have very good communicative skills like
I'll fill this gap. I think he went on voice. So a good example I can give you of exactly what Doctor is talking about. It's a family case, but not a marriage case. So I was asked to mediate a dispute between two cousins who had shared different stores that were falafel. You know, falafel, the Middle Eastern sandwich. So they had a couple of stores, and they wanted to part their ways. And I get this information. I think I'm going to be like God, right? I'm going to get these cousins talking to each other again and communicating, and the settlement's going to be they're back in business. And it was very clear to me that what I thought could never happen. They wouldn't sit in the same room. They never entered the same room until we settled it. One was here, one was there. And so we realize as mediators, our job is to settle their dispute. We can imagine these great ideas of success, but it's not our job to impose them on somebody. The disputants direct that. You can make an effort, but when somebody tells me they won't sit in the same room, no way I'm going to try to put them in the same room, because and that can apply to family too. When we do high conflict family cases, we make sure that we don't re-victimize. If someone's subject to abuse, they don't become re-victimized by the process we design as a mediator. Maybe Doctor's back and he can finish up. Yeah.
So we have another question from one of the students, Lagima Jain. Is the shift from the physical session to the virtual sessions have directly or indirectly boosted the campaign for greener arbitration?
Yeah, really. So we don't get paper much anymore. There's institutions that are asking people to sign the green pledge or whatever, everything like that. But that's one of the other side benefits of COVID is these issues, these environmental issues, where we all had to learn. To be honest with you, I still print out a document every now and then because there's something about the comfort of being able to refer to my summary sheet or something like that I prepared. But for the most part, the answer is yes. And I think that's even on huge cases. The beauty of this is, you guys know, the searchability of a document is amazing. I did that the other day. I was working on, it actually was a competition, and there was a particular thing said, and while we're online, I could search the document and make sure it appeared or didn't appear wherever I thought my question was going to go. And so most of us are going to realize that that digital documents make us better at whatever we do: lawyer, mediator, arbitrator, maybe even student, right?
So I think Professor Prakash is having some difficulty joining us. He's
Yeah,
trying.
I think
He's there.
I don't know
Yeah.
when
Okay.
it's happening.
Yeah. Okay. Now he's here. So this is a question actually for you from one of the students, Gini Rajvanshi. Do you think that the need of the hour is to expedite the regulatory framework for third-party funding in India, as alternate dispute resolution and arbitration has shown exponential growth, and third-party funding can act as a catalyst to spur the growth of ADR? So how in India can we have the speedy introduction of code of conduct and regulation around third-party funding, and whether it will be suited in the legal system as of now?
Third-party funding means what is the source of funding? From where you are expecting?
So I think this question is pertaining to foreign investments, probably, I think.
So it's funding for dispute settlement. It's autonomous and it should be under the control of Government of India only. So let there be London Court of Arbitration may come, and they may come on their own and they may establish their offices. But directly inviting funding in the dispute settlement mechanism may not be a good trend. It is just like you are inviting funding for the establishment of courts. So this is a sovereign activity. Okay. Sovereign activity in the sense that the certain disputes, commercial disputes, like what I said, Singapore Council of Arbitration wants to come and open its shop. It's okay. But getting funding for the establishment and giving the whole system and structure may not be a good idea.
Okay.
Because we are capable. In order to make ADR successful in India, the only thing is we need trained arbitrators, we need trained mediators, we need trained conciliators. Conciliator means he should do only conciliation. Then in the part-time, he should not go to the court by wearing a black coat. So litigation is a different ball game, and arbitration or mediation is a different ball game. The ball shape may be the same for basketball and volleyball, but the rules differ. So what we need is specialized branches. Even in arbitration also, there is maritime arbitration, there is construction arbitration, it is a medical arbitration. So it has been developing. The problem in India is, as I said earlier, it's the mindset. It's a mindset. We in the law schools, we should campaign. We should bring more awareness, and we should explain the common man that what are the advantages of ADR. So the accessibility, the time saving, the economical, and it is a parties-based dispute settlement. Suppose if you file a suit in the court, the court will control the parties. And here the parties will control the mediator. And what should be the rules, regulations that will are applicable to the dispute. It is the autonomy of the parties. There is a lot of autonomy to the parties in ADR mechanisms. That we have to explain, that we have to bring awareness. So today or tomorrow, India also has to move towards ADR mechanisms. No doubt in it, because our courts, they can't afford so much litigation. And the volume of work that the high courts and the Supreme Court, they have been dispensing, enormous. What are the federal Supreme Court judge in US, whatever he disposes in his entire lifetime, here in the Indian Supreme Court, the judge will dispose that much number of cases maximum in 1 year. It's a, if we see, because only limited. So our job is to bring awareness about ADR. Okay.
I think mindset is important. In my country, 95% of all cases that get filed get settled before a judicial decision. And in your country, it's quite the opposite.
Yes, almost.
Yeah, almost the reverse.
Almost reverse.
Yeah, and parallel to that is this idea that in mediation, for example, our experience around the world basically is 75% of cases that are mediated get resolved and paid. No subsequent proceeding. It's a satisfactory result. Now, keep those two thoughts in mind and think about the past year. You have a backlog problem in India.
Yeah.
I have a backlog problem by that I mean pending cases, right, in court systems. What did we do in the last year? Those pending cases didn't shrink. There's a huge bubble coming, right? There's a huge number of new cases that haven't been heard. So now, if we look at access to justice, as Purvi told us to do when we began this, is how are we going to get justice for any of those people? They had a dispute that may be COVID related. Are we going to tell them, we'll address this in 10 years? Maybe your children will inherit your case? Or when? Maybe it's not even 10 years. And so we have, as a society, have to look at what happened and see what changes need or can be made. System-wide, and the court systems are we were working on this with a group the other day, and to me the court systems is a Goliath, David and Goliath. It's just this giant system, and you can't get systems that big to change real quickly. We should have been using in my country, we should have been using this time to start redesigning our legal system before now, and we're probably going to begin to do that because COVID has created some possibilities, but it also has demonstrated a big need to make some fundamental changes. And most of it, doctors' awareness is not awareness to lawyers as much, but sometimes individuals. Is there ought to be case managers for anybody who has a dispute and talk to them about mediation, about arbitration, about litigation, and see what really system is going to work best for their problem. And sometimes it's court. We don't disagree with that.
Sir, due to time crunch, we won't be able to take more questions. But since we are live on YouTube channel, we have one question from a viewer. This question is to both of you. Can you put some light on how arbitration can be used in intellectual property right issues?
You want to go first, Doctor?
Yeah.
Go ahead.
Right. Okay. See, there is no specific, because if you, for that matter, any specialization, maritime arbitration is there, then the arbitrator, he should know something about Maritime Act, Shipping Act, and then Convention on the Law of the Sea. What is the basic structure of a ship? What are the maritime agreements, contracts? So similarly, when you are someone wants to specialize in IPR arbitration, so one should be very thorough with IPR laws, the developments, not only in India, all over the world. So as far as the procedure is concerned, it is more or less the same for any branch. See, in the court, there may be a variety of cases, but the basic procedure, it is the same. Similarly, if you want to specialize in the construction arbitration, you should know something about the construction industry, civil engineering, or architecture. So what is the sand, what is cement, what is the mixture, those technical terms. So except this, I don't think that you require any specialized training. The procedure, mark that the procedure for any kind of arbitration is more or less the same, procedural formalities. But one should have very good knowledge, very deep knowledge in the subject, in the area where you want to specialize. I think that's what one has to do. Okay.
I agree. I'd point out one additional thing. I think IP is particularly suitable to arbitration because of the confidentiality of it. If someone files a lawsuit against somebody else because of a breach of something, the public, in my world, the public can access those cases. So it can have reputational damage to both sides. If we choose an arbitration, it's a confidential process. There's no public courthouse where people can go and see, I didn't, or I stole this IP. And so I believe it's particularly suitable for arbitration and more in the needs of the client's interest. And the second reason it's suitable is some of those disputes need to be resolved quickly. And we can have expedited hearings in arbitration that might get some interim or temporary relief on the infringement or whatever it is, some kind of stay order pending solution. And so it's a fertile ground for it. But like Dr. says, the process is all the same. Just the litigants need to decide which is their choice. And I'm in favor of disputants using arbitration for IP disputes.
Okay.
Thank you, sirs. After such illuminating interactions with the students and the faculties, with the permission of ma'am, I would now like to invite Sanji Agarwal, student of semester 8, to initiate the official vote of thanks.
Yeah, Neha, just 1 minute.
Yes, absolutely.
Okay. I have to say that thank you very much, Purvi, and it's a pleasure to have Thomas, after my old friend, to share my thoughts along with him. And my request, my appeal is next time, discontinue with this Zoom, because we have discontinued Zoom, and most of the law schools, and for me, even I stopped attending the Zoom meetings. So please, because that much we should do. Yeah.
Yes, sir, I do agree.
I hope you won't mind.
No, sir. Thank you so much. In fact, all of our classes are going on WebEx. So our regular
WebEx
sessions, all the classes are on WebEx. We are just using for this month, just because it at times, all of our foreign speakers, some of them are very comfortable with using Zoom. So only for this month, for this special sessions, our all regular sessions are on WebEx.
WebEx only. That's a very good.
Yes, sir. Yes.
Yeah.
Okay. Thank you. Thank you, sir.
Thank you.
I'll give my thanks to everyone as well. It was thank you for having me. It's good to interact with all of you, and thank you for your interest and participation. I look forward to being with everybody again someday soon.
Thank you.
Okay, Thomas. I hope to see you in Vishkhapatnam.
I hope so
once
too.
Normalcy is restored.
Yeah, absolutely, absolutely.
Yeah.
Good.
Thank you. It's good to see all of you.
Yeah.
Thank you.
Sanji is a student chairperson of our ADR club.
Okay.
So welcome, Sanji. Yeah.
There's Sanji. I know Sanji. Yeah.
Hello, sir.
Oh, yeah.
Okay, so hello, good evening, everyone. After the successful conduct of such an insightful and thought-provoking session, I, Sanji Agarwal, student of 4th year, would like to take this opportunity on behalf of the Institute to extend a hearty thanks to Mr. Thomas Valenti and Professor Dr. S. Surya Prakash for taking out their precious time for us and throwing light on how ADR in current times is like a ray of hope in this pandemic when all the courts were closed across the globe. Thank you so much to both the speakers. We are highly grateful to Professor Dr. Purvi Pokhariyal, Dean and Director of ILNU, without whose support this would not have been possible. Thank you very much, ma'am. The most important thanks extends to Professor Neha Burani for moderating the whole session so flawlessly and putting forward the questions of the participants. Thank you very much, ma'am. Thanks to all the participants of the session who attended and posed such innovative questions in front of the speakers. Thank you very much, and we'll end the session here. Have a very good evening.
Thank you.
Thank you, sir.
Thank you all. Good night. Have a
Good
nice
night.
time. Yeah.
Night.
Bye-bye.